So what is a breach of authority? Breach of warranty of authority. If an agent has no authority or exit its, then the principal may rectify the contract and become liable. Okay. However, if the principal does not rectify, then agent will be the liable to the third party for the breach of the warranty of the authority, because he warranted or promised that he has the authority which he does not possess and which he does not have. Is it okay? Liability of an agent for the disclosed party. A principal is disclosed where the existence of the principal has been made known to the third party. Okay. It is not necessary for the principal to be identified to the third party, but ये ऐसे बोल दें कि yes, I'm working as an agent and I'm working for the principal. In that case, it will be known as in the case of the disclosed principal. Huh? As a general rule, the contract is between the principal and the third party. Okay, the agent is neither liable or nor entitled under the contract. However, the agent will be personally liable in the following exceptional cases. What are those? Where the agent so has intention to undertake the personal liability, in that case by signing the written contract in his own name, then in that case the agent will become liable, huh? Even though he's acting within the authority. Trade, usual or customs, where the agent refuses to identify the principal, in that case he will be personally liable. Where the agent is acting on behalf of the fictional principal, in that case he will be the personally liable. Okay. Liability of an agent for the undisclosed principal. An undisclosed principal is where the principal existence has not been made known to the third party. When the third party discovers the existence of the third principal, he can elect to treat the principal or agent as bound by the transition. Okay. Hello. Is it okay? Yes. This is a question that we have. Innominal is an agent of Mr. Faulty. He is allowed it to sell. Who is he? The agent, huh? To sell the goods at the minimum price of this unit. But to make a sale, Imran sell them at a unit. This is kitna low hai na? So who will be liable? This is a minimum price, right? Who will be liable to the buyer? Mr. Faulty, will he be liable? Yes, he will be liable to the third party, but this is very they have not given, hai na? They are just who will be liable to the buyer. So Mr. Faulty will be the possibly will be liable. But if we see what are the other options which are there, nominal for breach of the warranty of the authority. Sably, Mr. Faulty wife for recommending him. Then the buyer for being greedy. No. So this will not be an option. Ultimately, you will not be having this easy option in the exam. So you do not prepare yourself like this that way. So who will be the liable over here? Do you know what the warranty of authority? If in this case, if the principal is not going to rectify this, और why he would be rectifying यार, कि अगर आप मान को चलो कोई यूनिट आपको इतने में बेचनी है and you have sold this for this, तो कितना लो है पता है आपको, कितना परसेंटेज है इसका? 1% है, हाँ. So you are selling a thing at a 1% of what the price you have been asked. So क्या आपको लग रहा है प्रिंसिपल रेक्टिफाई करेगा इसमें? Would he would be doing that or not? Hello. In this situation, will the principal rectify the act of the agent or not? Samvit, Siddhant. He will not be doing rectification. So in that case, B would be the right answer. Huh. B would be the right answer. But if he would be taking the rectification, in that case, the A would be the right answer. Huh? Now we will learn about what is a fiduciary duty of an agent. Fiduciary duty means the agent has a duty to make decisions and take decisions with the intent of agent benefited in the minds. This would have been principal benefit in mind. Okay. So an agent fiduciary duty or agent personal interest must not conflict with those of the principal. Agent must act always in the principal best interest. Agent must not pocket a secret profit while making the working. This is a case. On this, you will see multiple of the question, or at least one question will be there. Ki, agar agent is making a personal profit, secret profit, in that case, he's doing something wrong. He's not working under the fiduciary duty. So whatever the personal profit or secret profit he's made, this need to be written to the principal. Okay. Agent must account all the money and property receive on the on behalf of the principal to the principal. So सारी चीजें जो property या money receive हुआ है, this need to be given to the principal. Okay. When an agent breach the fiduciary duty, when the principal can reject the contract, अगर principal अगर agent आपकी fiduciary duty को breach करे तो principal क्या कर सकता है? Okay. Principal can reject the contract with the third party. Agent can fire without notice period. Principal can deny paying any fee or money to the agent and recollect any money already been paid. But this is when this is a case. You will see multiple sort of the question coming out of this. कि ऐसा होता है कि if the principal is not paying the money to the agent, so what are the scenario where it is legally allowed it कि आप मत करो money, or where it is something would give rise to the problem. So in this case, the problem would be that key uh, principal is not allowed it, right? Principal is allowed it not to pay the money when there is a breach of the duty by the agent. Okay, is it okay?
Yes.
When the principal can recover any secret money made or any bribes taken by the agent. Huh? So these are the things when the agent will be breaching the fiduciary duty. These can be done by the agent, the principal. If what are the duties of the principal towards the agents? To receive, to give. Okay, give commission or remuneration for the service rendered. To claim an indefinite against the principal for all the expense reasonably incurred it. So मैंने second point बताया था ना कि वो भी जो whatever the expenses you are incurring when you are making a contact for the principal, in that case you can recover them. To exercise a lien over the principal property. The lien allow the agent to retain proportion of the piece property that is lawful in the A's possession until any debt due to A, that is areas of remuneration, has been paid by the B. So जब तक वो property पे राज कर सकता है, okay, he can take care of the property and he can take the control of the property. There are the two of the question which I wanted to discuss with you. Each one of you would be answering one and one question. Samvit, which one would you like to go with? Would you like to come with a 4-1?
Okay, sir.
So what is that? Explain me the question as well. Huh?
So in this question, Rick is Morty's agent, and he sold Morty's flat at a discount of 30% for a bribe of 500,000 rupees, 5 lakh rupees. So over here, uh, option A and option B, he will fire Rick and he will receive the bribe received by Rick.
Done. Good. Brother, good one. Samvit, would you please like to answer Siddhant? Would you come with the fifth question that is there? So who is an agent in this question? Arjun or Murthy?
Arjun is the agent.
Okay.
B.
Exercise lean over the years. But are you sure about it? That he is only paid 10% commission and he deserved 20% commission, and that was an agreement bit before making into the contract. Huh?
Both A and D.
So which option you would like to go with? A and B and C and D?
D, D.
Good one. Okay. We are going good. Now we will start part 2 of this chapter. This part discusses the different types of the business organization and the partnership. So we have covered the portion of the agency. Okay. Done? Hello.
Yes.
Now we'll start with the partnership one. Huh? So type of business organizations, that is in sole trader and sole proprietor. The owner proprietor is in sole owner and manager of the business. He is solely liable for the business debt. This form of the business does not require any specific legal procedure to be set up. It is not suitable for the large business. Example, your local florist and independent workshop, bookshop. Okay, done. So Siddhant and Samvit, whatever you can think is something you can understood. So we'll not be wasting our time on that. Okay, because again, this is an important topic. You probably have done this multiple of the time. Huh? This partnership specifically. Okay. But if there is anything that you want a discussion on, please do stop me there. Okay, without any delay. Is it okay? Hello.
Done, sir.
When we talk about the general partnership, this is more of the general participant that was there in maybe 1970 or 1990, or before that. So here two or more people comes together to jointly own or sometimes jointly manage a business with the common goal of the earning profit. कभी भी whenever you learn the definition of the partnership, तो you will not never see कि definition में loss आ रहा है कभी, पता है? This is a good observation you should be on to कि कभी भी आप partnership की definition पढ़ो तो you will observe that कि there is nothing, they will never mention you about loss. But whenever you are common goal of earning profit, तो जो आपका loss भी होता है ना, वो भी आप general partnership में equally divide करते हो. Here the liability of all the partners joint and several, that the liability of the partner is unlimited in the share among the each other. Okay, then there is an limited partnership. What is that? That here also two or more partners come together jointly own and sometimes jointly manage a business with the common goal of the earning profit. Guys, would you please allow me 5 minutes? Hello, guys, are you there?
Yes, sir.
All right. So here the two or more people come together to jointly own and sometimes jointly manage a business with the common goal of the earning profit. Although under such partnership, the liability of the one or more partners is limited to their capital contribution. A limited partnership must fulfill the following conditions. At least one partner must have an unlimited liability. अब यहाँ पे एक चीज देखी आपने, ये चीज ऑब्जर्व करिए आपने. द लिमिटेड पार्टनरशिप में क्या होता है कि एक पार्टनर की तो आपको देना पड़ता है. वन पार्टनर शुड बी विद अनलिमिटेड लाइबिलिटी, बट अदर देन दैट more than one partner can come with a limited capital contribution or that will limit their liability. Okay, but a limited partnership में ये चीज याद रखनी पड़ेगी, these are the condition कि एक partner की हमेशा unlimited liability रहेगी. That the partnership must be registered with the registration of the companies as a limited partnership. Okay, the registration of the company is basically this is body who look after कि कितनी companies registered हैं. Just like we do have MC in India. Okay, है ना? Registration of the companies are there in the UK. Limited partner must not participate in the management of the business. If they do so, they will have to forego their limited liability. Yeah? They will be taking care or taking the part of the management of the business, but ultimately they have to follow the instruction of the unlimited partner. Huh? Someone know what I mean to convey? They will not be the one who will be on the decision making power. Huh? Their point will be viewed on, their point will be listened and taken care of, but they will not be directly will become the person who will make the decisions. A limited partner is not an agent of the partnership. He has no power to bind the firms into the contract. Is it okay? Hello, is it okay? Then you will learn about the limited liability partnership. It is an artificial legal entity with a perpetual succession. Perpetual succession means कि जब आप LLP की बात करते हो, कंपनी की बात करते हो, so those are there into the market with an objective कि वो चलती ही रहेंगी. या there is no deadline which has been planned for the company. एक individual, एक human being की भी एक, there is a time when they have to leave the world. But companies जो होती हैं, they would not leave the world until unless they go for the bankruptcy. Yeah? Okay, so there are countries who are like in there for more than 200 years. Huh? It could possible, but human tendency इतनी नहीं है, human life इतनी नहीं है. So perpetual succession means that will go, that has not been a planned death. Okay. Artificial legal entity means it is not an actual living person, but it is an separate legal entity on papers. Perpetual succession means that it is not wound up after living or that of the proprietor or the partner. It is independent of those people and cease to exist only on the resolution or bankrupt. Okay. The liability of the partner is limited to their capital contributions. LLP must file annual account and annual report with company's house, and that will be the company registered in the UK. Is it okay? Hello.
Yes, sir.
When we talk about the company, so it is also a separate legal artificial legal entity, which we'll discuss in the later in this chapter. The business organization will be sole trader, general partnership, limited partnership, LLP, and company's house. Company. Huh? A partnership is a relationship which subsists between two or more persons carrying on a business in common view of the with a profit. A partnership can be a small operation has or with some large firms of solicitors and accountant partnership with several hundred partners. Okay. And if we try to understand what is the type of the partners, so there is a general partner, a partner who is actively involved into day-to-day running of the business. Then there is a sleeping partner, the partner who takes no active part in day-to-day running of the business. He is jointly and severally liable for the debt of the business. So this is an important paperwork area which you will be seeing in the exam, that they will try to know what are the type of the partnership that you know about. Okay, done. Then we have a limited liability partnership. A partners whose liability is limited to the amount of his capital contributions, he cannot take the part in the management of the business. Salaried partner, a partner who receives a fixed contractual salary in terms respect to the profit and loss, not a real partner unless he receives as a partner of the profit, part of the profit. Okay. Then general partner, sleeping partner, and limited liability partner. These are the partner conversation that we are having on. And if we move ahead, then we will learn about what are the characteristics of the partnership. The partnership business must be carried out. Hello, is it okay? Are we going good, guys? Hello,
Yes, sir.
are we going good now? I think those were the things की जो
Yes.
पढ़ के आ जाती हैं, so I'm not just spending more time on them. हाँ, ठीक है ना, चलेगा ना, will work.
Yes, sir.
Okay, done. So the partnership must be carried out with the intention of the earning profit. The following are not valid to create a partnership. That mainly joint ownership of the property. आप प्रॉपर्टी को ओन करने के लिए पार्टनरशिप नहीं बना सकते हो. देयर इज एन इंटेंशन टू अर्न द प्रॉफिट. पार्टनरशिप जब ही होगी जब आप प्रॉफिट के लिए आ रहे हो. ओके, mainly sharing gross earnings. So guys, Samvit isn't okay with Hindi sometime if I'm using. Siddhant, are you okay with the Hindi? Do you know or understand the same?
Yes, sir.
All right. So mainly sharing gross earnings, right? And mainly sharing the expenses. The partnership commences as soon as the partners start their business activities. They do not need to be legally binding on the documentation to start a business, unlike the companies and LLP do. Okay. The actual agreement of the partners may be drawn up after or before that date. The partnership can be implied or expressly, right? Partners are bound by the terms of the partnership agreement, and even if it is goes against the partnership act. Okay. Means there is in partnership act जो कि अपने general. So the discussion that we are learning about, these are about the general partnership, right? General and standard partnership, okay? And that was there in 1890, okay? अभी जो partnership की whatever the agreement, जो भी partnership का जो भी हमारे term and condition है, those will always prevail if they are going against the partnership act, okay? Done? But probably there will be one or two conditions ऐसी होंगी जहाँ पे होगा, otherwise it will not always be the case. And those are some of the exceptions which will be there. Other than those exceptions, what I can think of कि बहुत rare chances होंगे कि आप against जा रहे हो partnership act, क्या? ठीक है? Hello, done? Then you have a Cox and Cluson case. Yes, please. You were saying something, Siddhant?
No.
All right. C agreed with M that M would put on a play at C theater C traitors. C was to have 60% and M 40% of the gross box office receipt, right? C paid the expenses of running the theaters. Okay. C agreed with M that M would put on a play. So there's a C theater. C and M agreed that M would play or put a play on a theater. C will be taking a 60%. M would be taking 40% of the gross box office receipt, and C paid the expenses of running the theater, and M paid the expenses of the putting on the play. During the performance of the during a performance, the claimant who was in the audience was accidentally sued by one of the actor. The claimant sued C, alleging that C was M's partner and was jointly liable with M. So the decision on the court was that C was not liable. C was not M's partner because they mainly share the gross profit. तो मेनली शेयर मीन्स कि उनका बेसिक ये था कि बस वो ग्रॉस प्रॉफिट शेयर करेंगे, हाँ ठीक है। अगर यहाँ पे थोड़ा ध्यान दिया होगा, इफ यू हैव गिवन सम ऑफ द केयर ऑन दिस, यहाँ पे लिखा हुआ है कि द फॉलोइंग आर नॉट वैलिड टू क्रिएट द पार्टनरशिप। जब आप जॉइंटली ओन करते हो किसी प्रॉपर्टी को, जब आप ग्रॉस प्रॉफिट को शेयर करते हो या फिर आप शेयर करते हो एक्सपेंसेस को, तो आप नहीं हो। आपका इंटेंशन ये होती है कि जो भी प्रॉफिट होगा ना उसे साथ में करेंगे। इफ दैट इज योर इंटेंशन देन द पार्टनरशिप इज देयर, अदरवाइज द पार्टनरशिप इज नॉट देयर। द केस वाज देयर कि वहां पे जो सी एंड एम का था ना, वो किसका था, दे आर जस्ट गोइंग टू डिस्ट्रीब्यूट और दे आर जस्ट गोइंग टू डिवाइड द ग्रॉस, दे आर जस्ट गोइंग टू हैव द ग्रॉस, वॉट एवर द ग्रॉस था वो रिसिप्ट का वो डिवीजन करना था उन्हें। ओके, then C was not M's partner because they mainly share the gross profit receipt. Is it okay? Hello. Now we will just go through to the question which are there. This is question and 7 question. If it says that Andrin Balton rent an open ground owned by her to a band called Famous Five, Balton pays for maintenance of the ground and Famous Five bears the expenses of conducting their show. Balton get 20% of the revenue and the rest goes to the five. Is this a partnership or not? Which option you would like to go with? Siddha, Samvit.
Option A.
How they are partner? Is this they are on the motive of the profit earning, or they are just sharing the revenue, or they are just divided that one party will be taking the expenses, the other party would be taking the other maintenance, and whatever the revenue we will just share the 20% with the person who has in ground and 80% will be on me. So can you able to see the focus is on the maintenance, the focus is on the expenses, right? The focus on the revenue sharing. अगर आप पार्टनरशिप में हो तो आप ये नहीं देखते कि आप कितना एक्सपेंस दे रहे हो, आप टुगेदर वी जस्ट पे द एक्सपेंसेस थ्रू द मीडियम ऑफ द पार्टनरशिप, राइट? समझ रहे हो ना? सो दिस इज नॉट द केस, दिस इज नॉट द केस ऑफ द पार्टनरशिप, दिस इज एग्जैक्टली द सेम थिंग दैट वी हैव डिस्कस ओवर हियर। जो केस हमने यहाँ पे पढ़ा है उसका केस नीचे बन के आ गया था। सो आपको ना तो याद रखना था कि कौन सा केस है, ना आपको याद रखना था कौन सा डेट है, बस आपको याद रखना था कि व्हाट इज द रूल एंड एप्लीकेशन। ओके, दिस बोथ थिंग्स हैज नाउ बीन टेस्टेड इन दिस केस ओनली, मतलब नीचे ही आ गया आपके, ठीक है। एंड द क्वेश्चन पेपर will look like the same. 7th question which is there, which says that allow me, I think this need to be done open. Yes, now I can see the question. Rose and Nikhil Chandela and joint runs a business which is bound up because of Rose death. Is this likely to be LLP? LLP means it is like a company, है ना? So company not bound, they own the perpetual succession. Okay, ठीक है, done. Hello guys, are you there?
Yes, sir.
The type of the partnership we discussed above are the based on the UK law and also form in many countries around the world. But has the nature of the international business and law, they are the still during there is still different variant of the partnership around the world. We will discuss two of these systems which you might remember from the chapter 1. That is in civil law partnership. A country where you can find this system is in France. Okay, so site norms collective, I don't know how to pronounce this. It is similar to unlimited partnership in most way, except that here the sink has an corporate legal entity. Yeah? This doesn't mean that it is responsible for its own debt. The partner is still jointly and severally liable for the business debt. So you need to learn the characteristic. क्योंकि हर एक partnership की characteristic are different, so you need to learn them. Because the question would be set will be based on the characteristic of the partnership. हाँ? They will not be asking you to write, but option क्या आएगा? मतलब question यही आएगा ना कि आप characteristic जानते हो नहीं जानते, तो you need to learn them. हाँ? Even the manager that is granant of the business are liable for the एसएनसी जैप. दिस इज समथिंग वेरी न्यू कि आपकी पार्टनरशिप में मैनेजर भी लायबल है. पार्टनर्स आर ट्रीटेड लाइक सोल ट्रेडर्स फॉर द टैक्सेशन पर्पस. दिस इज समथिंग ऑल्सो हैपन इन द जनरल पार्टनरशिप कि आपको बस प्रॉफिट डिवाइड करके दे देंगे पार्टनरशिप में. फिर इंडिविजुअल जो पार्टनर्स हैं दे पे देयर टैक्स बाय देमसेल्फ. हाँ, द पार्टनरशिप फर्म डू नॉट पे टैक्स ऑन देम. The only decision that require the unanimous approval are the transfer of the shares, removal of the partner, and cessation of the trading. Okay, is that okay? Then we have society and commodity. These are similar to the limited partnership. The key difference from the SNC is that some partner are given the right to the limited liability. If we learn about what is in Sharia law, partnership musharakha is a form of partnership in Islamic jurisprudence. It is driven from sirka, which means sharing. It is divided into the two type. Sikakat ul milk. It is the ownership of the property by two or more people. Sirkat ul Akh refer to a joint commercial enterprise, essentially a partnership created by the mutual contract. Okay. More of the things which you need to learn. I can see over here. So what I'm expecting that you will be revising the same thing, huh? And just try to learn the key pointers. That will give you the idea like how you have to deal with the questions. Srikat ul Akh is a further subdivision of the into the three types of the commercial enterprise. One of which is Srikat Ulk Mla, which is sometimes known as an Musharak, a partnership relationship established through the mutual contract. The proportion of the profit to be distributed among the partners must be determined by the contract, and if it is not, then the Musharak is deemed to exist by the Sharia law. Partners are liable according to the investment they have made into the business. If they contribute 20% of the capital, they're liable for the 20% of the debt. The partners are considered to be against of one another unless it has been agreed that some partner are also excluded from the management. Mudraba is in contract where at least two parties join in a commercial ventures, one of whom is has finance, another of whom has no finance, but say ideas and entrepreneurship. The financer Rabul Mullah enable the entrepreneur Mudarib to undertake a business enterprise. The financials is entitled to agreed share of the profit, but has a no management right into the enterprise. So who will be taking after the management? The one who is in Mudarib. Okay. Then we have an authority of partnership under Act. So what are the authorities of the partners which has been given to the partners under the Partnership Act 1890? Each partner is considered as an agent of the business and other partner unless otherwise specifically stated. Each partner is assumed to have an implied authority to sell the goods of the firms, buy goods that are necessary or frequently used by the firms, collect debt payment for the firms, hire employee, appoint a solicitors to defend the firms in the case. The above authority is given to both the traditional trading and non-trading partners. The trading partner have additional authority to borrow fund from the firms. Trading partners, right? A question would be there कि किसके पास authority होती है to borrow the fund, so it will be the trading partner. In order to claim the implied authority, the partner must behave within the usual scope of the partner's power in a particular business. If we just move ahead, which is this question, which you can just attempt by yourself, give it your thought. I think you can do this. I'm just covering on the portion because we are just left in time now, and something we can cover in this chapter because there is less than a 1 or 2 page or 1 or 2 more topic which is left, and there is no more of the explanation. But we need to go for once at least. What is the limited liabilities of the partnership debt? If there is in partnership who is in debt, so what will be the liability? A firm is liable for the contract made by the partners acting within their is actual and implied authority. Okay. अभी देखा ना कितना एम्प्लॉयड और अथॉरिटी वाला वो कॉन्सेप्ट यहाँ पे आया कि पार्टनर्स एक एजेंट है एक पार्टनरशिप फर्म का. ओके. The partner is not bound by the implied authority of the partner if the third party knows that the partner has no actual authority. In that case, they will not be bound by. And if we just look around that, the partner has no actual authority and the third party does not know or does not believe him to be partner. If word isn't holding out, so every person who by his word or conduct represent himself or knowing allow himself to be represented as a partner is liable as if he is a partner to anyone who is thereby gives credit to the firms. Okay. What is the liability in tort? Where a tort is committed during the ordinary course of the partnership business by by a business or by partners acting within the authority of within with the authority of the other partners, द पार्टनर्स आर जॉइंटली एंड सेपरेटली। इसका मतलब ये है कि अगर मान के चलो कोई पार्टनर है और वो अपनी कैपेसिटी में काम कर रहा है और उसने कुछ ऐसी चीज कर दी जो दैट इज कमिटेड अ टॉट, तो उसके लिए सारे जो पार्टनर्स है ना, दोज आर विल बी लायबल अलोंग विद द पार्टनरशिप। ओके। misapplication of the money or the property, in that case the partnership is liable to make goods the loss where a third party money or the property is misapplied after being received by the partner within his actual and apparent authority or while it is in the custody of the firm। अभी मैं ये आपको बताऊं कि और एंड में डिफरेंस देखना, ठीक है। क्वेश्चन इस और एंड पे भी आ सकता है, सो बी प्रिपेयर फॉर इट। ओके। then these are the caution which you can just give it yourself a time and just attempt. I'm not just taking because we have also attempted many of the questions. If we talk about what is the liabilities of the partners in different situations, in that case, if we talk about the general rule, so every partner is jointly and severally liable for one of the important area. Okay, यहाँ से क्वेश्चन आएंगे, 3-4 क्वेश्चन और 2 to 3 क्वेश्चन विल बी देयर इन द पेपर। जनरल रूल में क्या है कि हर एक पार्टनर की जॉइंटली एंड सेवरली लायबल है। आउटसाइडर कैन सी वन पार्टनर अलोन और द फर्म। न्यू पार्टनर इज नॉट पर्सनली लायबल फॉर डेब्ट बिफोर हर एंड हिज ज्वाइनिंग। Retiring partner remain liable for that any debt incurred when he was a partner। और अगर रिटायरिंग पार्टनर ये चीज नहीं क्लियर करता थर्ड पार्टी के साथ, नाउ आई एम नॉट हिज पार्टनर, तो जो भी जब तक वो क्लियर नहीं करता ना कि मैं इस फर्म का पार्टनर नहीं हूँ और थर्ड पार्टी को लगता है कि ही इज स्टिल द पार्टनर, इन दैट केस ही विल बी लायबल। इफ द फर्म गिव नो नोटिस ऑफ द रिटायरमेंट, इट इज स्टिल कंटिन्यू टू बी बाउंड बाय हिज एक्शन। ओके। एंड दैट देन ही कैन यूज द पावर ऑफ अपेरेंट ऑथोरिटी, और वो कोई कॉन्टेक्ट भी कर सकता है। ओके, दिस इज एन लूप होल दैट कम्स इन द रिटायरिंग पार्टनर। What are the changes partner? When a third party deal with the partnership after change in the partnership, all of the partnership of the old firm are still treated as partner until the third party receive notice of the change. The previous customers are required action notice, and third party who were not existing customer can be notified by the notice in the London Gazette. So what are the changes we made? अपन ना यूके में क्या करते हैं, just to give it a guidance to all the general people, अपन ये करते हैं कि वैसे लंदन Gazette में डाल देते हैं, so that every individual who can just give it a sense and give it a reading. This is known as a constructive notice. Okay. Notification must take place prior to retirement if the retiring partner is to avoid liability for contact entered into after his retirement। तो उसे पहले बताना पड़ता है कि मैं अभी जा रहा हूँ, I will not be liable for anything that will happen afterward। Okay. Then we will talk about what is a novation. So it is a creditor agree with an outgoing and continuing and incoming partner that liability of existing partner will be that of the continuing incoming partner। ऐसा हो सकता है कि जो एक पार्टनर जा रहा है ना उसकी liability might be सेटल ऑफ कि जो पार्टनर जा रहे हैं इसे जाने दो, जो पार्टनर नया आ रहे हैं ना, who will that will distribute the liability whatever the existing liability of the retiring partner। Okay, or whatever the liability they were having when the existing partner was there। Thus the liability of the outgoing partner is removed and incoming partner become liable for the debt even though it was incurred before the become a partner। Okay, what is an indemnity? The continuing and incoming partner may agree to indemnify the outgoing partner against the debt incurred pre or post retirement। Indemnify means that they have a right to claim। If we talk about the dissolution, in that case a partnership is concluded without a court order कि पार्टनरशिप कंक्लूड हो सकती है कि पार्टनरशिप को ऑर्डर मिल सकता है कि वो डिसॉल्व हो जाए। ओके, कब हो जाए? विदाउट अ कोर्ट ऑर्डर, वन ऑफ द पार्टनर गिव नोटिस, द एक्सपायरी ऑफ द फिक्स टर्म्स ऑफ द कंप्लीशन ऑफ द स्पेसिफिक एंटरप्राइज, जो भी रीजन था उसके लिए आए थे वो कंप्लीट हो गया। डेथ और बैंक्रप्सी ऑफ द पार्टनर, मैंने बताया था आपको कि अगर एक पार्टनर जाता है, एक पार्टनर की डेथ होती है, वी आर टॉकिंग विद द जनरल पार्टनर, तो इन दैट केस में जो ओल्ड पार्टनरशिप फॉर्म होती है ना वो एग्जिस्ट होती है, और जो न्यू पार्टनरशिप होती है वो न्यू पार्टनरशिप फॉर्म रजिस्टर करानी पड़ती है। ठीक है, तो कंटिन्यूइंग ऑफ द पार्टनर वुड बी इलीगल। ओके, by the court order, the partner has mental disorder, the permanent incapacity, partner engaged in activity prejudicial to the business, partner willfully or persistently breach the partnership agreement। Okay, then partners conduct himself in a way that is no longer reasonably practicable for the other to carry on a business with him। Okay, then business can only be carried on the loss। In that case the business court might give order to dissolve the firm। It is just inequitable to do so। just inequitable to do so means कि this is the best option in the scenario। okay, कि कुछ ऐसी चीज हो गई है कि यहाँ पे सबसे बेहतर यही होगा कि वी जस्ट स्टॉप द फर्म। सो कोर्ट ऑर्डर करती है कि टू गेट योरसेल्फ डिसॉल्व। ओके, अभी कोर्ट से तुम जब रिजोल्यूशन लेते हो तो there will be so much of the advantage तुम्हें मिल जाते हैं, like obviously you have to pay the liabilities to the creditors, but if the court is giving, so you will be having some liability, you will be having some relief in the liability. This is the practical case I'm talking about कि हो सकता है कि कोर्ट दिखा दे आपको बैंकरप्ट, तो मोस्ट प्रोबेबली अगर आपको क्रेडिटर्स को पैटर्न नहीं, क्योंकि अल्टीमेटली दिस इज केस इन द लिमिटेड, क्योंकि डिफरेंट टाइप्स ऑफ पार्टनरशिप, अगर जनरल पार्टनरशिप है इवन बैंकरप्ट भी हो जाएगी तो आपको पैसे देना पड़ेगा, ठीक है, बट इफ इट इज समथिंग दैट इज लाइक इन एलएलपी और समथिंग लिमिटेड पार्टनरशिप, तो वहां पे आपको बैंकरप्ट दिखा दोगे तो द पार्टनर्स हु विद द लिमिटेड लायबिलिटी कैन बी सेफर साइड. ओके, व्हाट आर द डिस्ट्रीब्यूशन, अगर आप पोस्ट रिजोल्यूशन हो गए हो, मतलब आपकी फर्म डिसॉल्व हो गई, तो व्हाट विल बी द डिस्ट्रीब्यूशन ऑफ द एसेट आफ्टर द पोस्ट रिजोल्यूशन. इन दैट केस, this is frequently tested in the exam in the practical forms. Make sure you remember the order of the precedent. This is an important portion. ये पूछा जाता है आपसे एग्जाम में कि किसको पहले आप दोगे. और आई हैव सीन मेनी क्वेश्चन. आई थिंक व्हेन आई वाज अपेयरिंग फॉर माय सेल्फ पेपर, माय पेपर, दिस वाज अ क्वेश्चन देयर. In the event of the resolution of the asset of the partnership will be used to pay off the debt of the partnership. A partnership does not have the advantage of the limited liability status if the proceed of the sale of the asset does not cover all the debt, then the partner personal wealth will be called up to make up the shortfall. But ये कहाँ पे हो रहा है, ये कहाँ हो रहा है, एक स्टैंडर्ड और जनरल पार्टनरशिप में हो रहा है, ठीक है. दिस विल नॉट बी देयर व्हेन देयर इज अ लिमिटेड पार्टनरशिप और एलपी. द proceed from the sale of the asset will be applied in the following way, कि सबसे पहले आउटसाइडर को देना है, these are the creditors. देन आपको पेइंग द पार्टनर्स एडवांस, एनी एडवांस दे मेड, कि पहले तो आपको देना है कि एक्सटर्नल क्रेडिटर्स को देना है, फिर आपको इंटरनल क्रेडिटर्स को देना है, मींस पार्टनर ने अगर कुछ कंट्रीब्यूशन किया हो तो देन पार्ट पेइंग द कैपिटल कंट्रीब्यूशन टू द पार्टनर. जो भी कैपिटल कंट्रीब्यूशन में है, जो भी कैपिटल कंट्रीब्यूशन में रेशियो में दिया गया है, वॉट एवर इज लेफ्ट ओवर आफ्टर पेइंग द क्रेडिटर्स, और कोई लोन लिया डायरेक्टर से या फिर पार्टनर से, उसे देने के बाद यू कैन डिस्ट्रीब्यूट द मनी टू डिफरेंट पार्टनर्स, राइट. If there is a residual remaining, this will be divided between the partners in the same proportion in which they have shared the profit of the partnership. In the event that the asset was insufficient to meet the debt to the outsider, अगर मान के चलो आप यही दे रहे हो, अगर इसी के लिए आपको सारे पैसे नहीं है, तो फ्रॉम द देन प्रॉफिट हेल्ड, जो भी प्रॉफिट था हेल्ड फ्रॉम द प्रीवियस ईयर्स और पार्टनर कैपिटल विल बी यूज टू मेक द गुड, मेक गुड टू द शॉर्टफॉल, जो भी शॉर्टफॉल है उसे बनाने के लिए वी कैन यूज दैट वे. एंड इफ दीज आर insufficient, then the partner will individually contribute in the proportion to which they share the profit. Okay, then you have a quiz which you can just give it to yourself, and we are done with this chapter. Okay, next time when we will see or meet tomorrow, we'll start with this concept. Okay, the corporate and legal liability. Is that okay? Hello guys, are you there?
Yes, sir.
So you will be attempting some of the question by yourself after giving a reading. I think we have covered this chapter with honesty, and this could be there in your 8 to 10 marks. These are easy 8 to 10 marks. You should not miss on. Okay. And with this note, we are done with this chapter. We have already covered 71 pages from 138. It does mean we are half the way. So we are done with this chapter. We'll continue this one and then we'll come on this and we'll wrap up this portion. Okay. So if we just need to calculate what is a portion that we have completed, in that case, it would be like that 25 marks, 8, that makes 41, and then 10 marks. So we have almost covered 50% of the paper. Okay. Done? At least 40 to 50% because the proportion got changed, right? Sometimes they give more question from one topic, sometimes they do not test altogether. So this is something else, because ultimately if you all together all this, तो आपका बैठेगा ना वो, so 110 marks का paper बैठेगा from all these areas. So we can expect 40 to 50% of the paper has been done. So with this note, I will like to go with the signing of today's lecture. Is there anything that you would like to ask, or we can wrap up the session? So you have to attempt the questions, and we'll start with the next chapter. After completing all this chapter, we'll be back to the question. Okay? Is there anything that you would like to ask? Or we are done with the day for the day? Hello, guys.
Yes, sir.
We are done for the day. Please speak faster. We are less than 1 minute, or else we have to join this again.
Yes, yes.
Samvit, are you there? All okay?
Yes, sir.
Pakka?
Yes.
चलो कल मिलते हैं. हाँ? Take care. Have a good time.
Thank you, sir.
Bye. Have a good time, both
Thank
of
you,
you.
sir.
Bye.